therefore calls for no interference of the judgment and order dated 21/06/2021 passed by the Special Judge POCSO. Accordingly, the appeal is dismissed and disposed of.
Item number 2 for the prolongation of judgment.
We have allowed the writ appeal, holding that the petitioner would not be entitled to receive a remuneration in the minimum of the pay scale as authorized to the post of LDC in the regular establishment. However, the conclusions as drawn by the learned single judge with regard to the regularization of the services of the respondent public writ petitioner herein is not interfered with. There are some corrections. You will get it uploaded by Monday. Chamber में दोनों chamber में
Yes. Yes. Case for but we need to notice first.
Then let's issue notice.
Yes. Who's the for the petitioner?
Yeah,
Right, so online.
I'm for the petitioner.
Yes.
Lordship, name has
Oh.
not been reflected. Well, this is we are seeking an independent inquiry to a massive embezzlement of public fund in awarding compensation amount in the Upper Siang district. Well, what has happened? The brief facts are that on an earlier occasion, on the complaint filed by the petitioners of the village that anomalies were there and siphoning of government fund was there, the court, the Lordship will turn to page 61.
My lord, in this case, only SSC investigation is going on and charges has been already filed, my lord.
Well, I have not
Against-
completed
yes,
my
Against all the delinquent officer and other things. my lord.
Let
And
me
sec-
complete, but he's unhappy with the process in which the SIC is going on, I think. Anyway, let him complete,
Yes,
let him complete.
Lordship is very correct because the fact-finding mission, on 2 occasions, the Deputy Commissioner, the government has constituted a fact-finding commission. The reports are never made public. And our grievance is that we could document that 65 crores prima facie there's a loss. Well, one page, one document I'd like to read that will clear the entire case. Well, a seriousness of the case. The Lordship will come to page 98. One document. I won't trouble your Lordship. Well, let them file a status report if the
Okay,
inquiry.
now, who's the petitioner? He's a very, persistent in his matter? Who is
Yes,
he?
my
Who's
lord,
the petitioner?
well, the petitioner is
Paragraph 5, my lord. Paragraph 5, my lord.
Who's the
Credential of the
petitioner?
the petitioner could document because in
What
the
does he do that he is
he basically he is an
pursuing this
cultivated-
matter? Okay,
No, he
yes.
has been, my lord, what has happened? He is pursuing a matter relating to corruption in public places, and the Supreme Court till the recent year 2023 has said a public spirited person can always challenge the action of the
Okay, he's a self-employed youth.
Yes, he is also doing some works of
Yes, past class 10.
class 10 and
12.
he's doing
So he's a
some
class
work-
12 pass.
Yes, my lord.
And
Qualification, of course, he is not.
does he belong to any NGO?
No, he
No.
doesn't
Okay,
belong
or
to
this
any class.
private?
Because on earlier occasions also he has filed some PIL where cases are pending. So his main purpose is probity in public administration. That's his only. And he has through the public domain for RTI.
Same petition I had filed this petition. Whether it's related
Yes,
to
my lord,
the
the same petitioner on the earlier occasion when he filed.
You had
petition-
approached this court
Yes, yes,
previously.
yes,
and
It was rejected on the ground that at that point of time he could not place some particular facts. But at paragraph 14, the learned division bench clearly said that it won't be a bar for him to
It
take up the
cannot,
course
because
in the
you
future.
That's what I meant.
See the next
to say.
See the next page of the conclusion portion.
Hmm.
That this order shall not bar to an affected person from taking recourse to such statutory remedy as they may be entitled.
Yes,
How can this petition be
See,
made?
we are reading page 117.
yes,
Okay.
sir.
The conclusion of this court
117.
in the previous PIL filed by you.
Yes, yes, Lordship.
So the conclusion as to how the previous PIL was dismissed,
Yes.
okay, that
Gave
is
us liberty.
that you were not barred from
None-
taking recourse
from
to
effect-
such
any effect-
statutory
Remedy.
remedy.
Yes, we have taken
Yes.
recourse to
Affected
statutory
person, not an
remedies
affected person.
by filing a specific more materials before the superintendent of police. And when this was not being done to we approached the chief secretary also. So we proceeded with full statutory remedies and
But
now. our-
yes, now
only
you are not
because-
affected, you are not affected
No,
by
I'm
this.
not this. I have
uh,
come for a larger public interest because the reason is that if your lordship reads one document, I could get documents and they were not giving me access to documents. To RTI, I was asking for reports, but one document I
Wait,
could
wait,
get.
let's see, yes,
Can
now.
can I read page 98? Your lordship, I'll
Okay,
just
let's-
it'll be
let's-
more clear because I'm.
Because we are wondering whether this can constitute a public interest litigation.
What
When
I'm.
it appears that the affected persons,
Yes,
you feel that certain persons have been affected
yes,
because the compensation which they are entitled to,
yes, yes,
okay, have not been paid to them.
yes, yes.
And that there is some siphoning of the money by
Massive,
some
massive,
officials.
massive.
Okay?
That's the paper,
But-
98 page.
But the affected persons,
Yes,
the observation of this court in the previous PIL
yes,
was that it is the affected persons, okay,
yes,
who should approach the appropriate authority.
yes, Madam.
Now, it appears that you are not the affected person, and in
can I-
spite of the order of this court while disposing of the PIL dated 05/05/2022,
Hmm.
you have again come.
What is saying?
Because I have got materials, Lordship.
So-
And the concept of PIL has been expanded. The locus standi has been expanded by the Supreme Court in umpteen number of cases. And in fact, if
So,
I.
do you have those cases ready with you
Yes,
today?
I have, only the problem is that I won't, the most important.
Then you have to give us the copy.
Yes, that's, Malad,
So you come fully prepared to convince the court
Yes.
that this matter
Yes.
involves,
Larger
is
public.
appropriate to be taken up as a
Yes.
public interest litigation,
Yes,
okay?
yes,
Mainly because this court in the previous PIL files had
yes,
noted that
Yes.
it is for the affected persons
yes,
to approach the appropriate authority. And
yes,
on perusal of the nature of your PIL, it appears
Yes.
that you are not personally affected.
but the
Okay.
the division
So,
bench.
so you have to convince this court that
Yes.
it is not the only the interest of the affected persons, but it is in
The
the
larger-
interest of the
the larger
general
public
public at
interest.
large. Okay?
Yes, yes,
So come with your authorities
yes.
and
yes,
we will
prepared.
consider whether the PIL deserves to be, deserves any further consideration at the motion stage, okay?
And
Heard
in-
Mr.
DK Das.
DK Das, learned counsel for the petitioner,
So, Mr.
and also heard Mr. Learned additional, so and so, for the state respondents. Having heard the submissions made, this court find it fit to adjourn the matter for 1 week, list on, when do you want it?
Malad,
5, 6, anything after?
Yes, can it be after 6?
Yes. Uh-huh.
Can it
List on 6,
6, Lordship.
6/8, 2024. In the meantime, the petitioner is to bring the authorities to be relied upon to convince the court that there is justification in filing a second PIL petition in spite of the previous PIL being disposed by the court in PIL 7/2022 dated 05/05/2022. Okay. Accordingly, list on so and so.
My lord, I'm appealing for respondent number 11.
Okay, when we say, okay, the presence of Mr. So and so, learned counsel for,
Respondent SIC.
okay, learned counsel for SIC and
And my lord, I'm for respondent number 12.
Mr. So and so, learned standing counsel for land management is noted.
Well, actually, one thing I just like to point out, the division bench, after rejecting, gave me the liberty to approach. That liberty was there.
Okay, so
That
so
your
you have
lordship is
approached, but you have to convince the court that
Yes.
this is an appropriate matter to be filed as a PIL. Okay. Yes.
Obliged. Obliged.
Item number 4.
May I plead your lordship? My lord, this IA is for condemnation of the 96 days. Condemnation of the lane.
How many days?
96, your lordship.
Heard Mr. So and so, learned counsel for the
Yes.
applicant slash appellant. This is an application filed under section 5 of the Limitation Act, 1963, praying for condonation of a delay of 96 days in filing the writ appeal against the judgment and order dated 20/03/2024 passed by the learned single judge in WPC number 24/2021. Issue notice to the respondents, Mr. So and so. Learned counsel accepts notice on behalf of
One, your lordship.
respondent number 1, while Mr. So and so accepts notice on behalf of respondent
One and
number
two.
2.
Yes.
Yeah, what about 3 and 4?
3 and 4, we have to serve
Okay, notice is to
through
be
ID.
issued to respondent number 3 and 4 through registered post with AD within 3 days, returnable by 3 weeks, list after 3 weeks. In the meanwhile, requisite extra copies of the application IA, okay, is to be duly furnished to the learned counsels for the respondents. Yes,
Right.
we can write.
Yes.
Yes,
Please, Your Lordship.
long
I'd
line
like,
again. What's the
I'd
line
like-
about?
I'd like to mention unlisted one item, this eviction matter, Lordship.
Yes, for Monday.
Lordship, Monday, by Monday, it will become infructuous, Lordship. Today only, if it could be taken up. Otherwise, it will become infructuous. I have already filed a petition.
Okay. Allowed.
Obliged, Lordship.
Now there's this long line. Is it with regards to the supplementary hearing listed for today? Yes? Okay, yes.
My lord, I would like to mention item number 28 for adjournment. As-
28.
Yes,
Okay. Mention is
It-
made on behalf of,
my name is there.
okay, Mr. So, your good name?
El Kagong.
Okay, Mr. L. Kagong, learned counsel for the
It may be fixed
petitioner,
on Monday.
has prayed for adjournment of the matter. Accordingly, list on, make
Monday.
it the next Monday, okay, okay, list on, what's Monday?
And
What's
this-
Monday's date?
29.
List on 29, so and so. Or make it after 2 weeks, while you're going to have the hearing. See, in the last week, next week, okay, next week, unless there's some urgency in the matter, I'm not very inclined to take up hearing matters. Because I'll be there only for that week till Thursday. I'll not be there on Friday also. Okay, so we'll make it on, list it on 5th, that's a Monday.
Yes, yes, sir.
Listed on 5th, 8th, 2020.
Much obliged.
Yes.
My lordship, I beg to mention item number 26, mentioning on behalf of M. Kato, taken consent from the other party also.
Motion is made on behalf of Mr. Encato, learned counsel for the respondent, for adjournment of the matter with the consent of the appellants.
And
Yes,
after 2 weeks, ma'am.
after 2 weeks.
Not one more item, I know. Actually, item number 8, my lord.
It is not in the, what is the stage?
My lord, I don't have the brief of the case.
Huh?
I don't have the brief of the case.
8.
Yes, my lord.
Then we'll see what is this stage, okay? RSA, so are these substantial questions of law framed?
My lord,
Not
I
yet. Okay,
no
then
idea.
you wait, we'll look at the file.
Okay.
Oh.
But
If I may, my lord, I beg to mention an item for listing on Monday.
What is the urgency?
Lordship, there is the CC is pending in this matter. So it's a criminal petition for quashing. The CC is pending
Under which sections?
under section 376 and 420.
376.
Lordship, it is a on merit, Lordship, not on settled merit, Lordship. We have filed it on merit. We are going to argue on merit regarding the quashing, Lordship. The CC is pending, so we are seeking.
So even if it's CC is not the end of the world. Let the case continue.
Lordship, the petitioner is facing harassment because no materials is made out against him still.
So if no materials is made out,
Yes, sir.
at the stage of CC also, the trial court can make out if no materials, then this can be straight away, acquitted or discharged.
But Lordship, the petitioner, he being a government servant, especially Lordship, coming to court, these things are hampering him, Lordship. So if it could be taken up and disposed of, Lordship, then that is our prayer. Kindly, Lordship. On Monday, Lordship, if possible, Lordship.
Okay, list on Monday.
Much
List on Monday.
My lord, I beg to mention item number 6, ma'am.
Item number,
6, ma'am. My lord, I have informed the other side, my lord, petitioners.
what is the stage? 6, what are you supposed to do?
I was supposed to file affidavit, my lord.
File?
Affidavit, my lord. Counter affidavit.
Okay, wait, let's finish with the supplementary hearings first, okay?
Your ladyship, I like to mention item number 23, 24, and 25.
23, yes.
I'm on behalf of learned senior counsel, Bori.
Okay,
praying
Mr.
for-
So-and-so, appearing on behalf of Mr.
Bori.
U. Bori, learned counsel for the petitioner, has prayed for adjournment of the matter. Accordingly, list after 2 weeks.
If the matter may be taken after 4 weeks. Your
Okay,
ladyship.
accordingly, as prayed for, list after 4 weeks.
Obliged to.
My lord, like to mention item number 5.
It's not in supplementary hearing list. Any other supplementary hearings to be mentioned? Item number 27 is remaining. Anyone for item number 27? Yes. Adjournment, yes. You're appearing for?
My lord, I am appearing on behalf of Benja Arun, item number 27.
Okay, mention is made on behalf of Mr. So-and-so, learned counsel for the appellant, for the
No, my lord,
respondent.
for adjournment.
Yes, you're appearing for whom? Counsel for the appellant or for the respondent?
I'm from respondent.
Appearing on behalf of learned counsel for the respondent for adjournment of the matter. Consent of the appellant has been taken?
Yes,
Okay, with the consent of the learned counsel for the appellant. Accordingly, list after
2 weeks.
2 weeks. Yes,
My lord, I would
supplementary
like to-
hearing over. Now let's come to the usual list.
Item number 1.
Section 11 application, Lordship, for appointment of arbitrator.
Pardon?
Section 11 application for appointment of arbitrator. Lordship.
Yes. Okay, will issue notice.
Please.
Heard Mr.
E. Kakoti.
Etago, learned counsel for the applicant who has filed the instant application under section 11 of the Arbitration and Conciliation Act, 1996 for appointment of an arbitrator. Issue notice to the respondents through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks on the date to be fixed by the registrar.
Any date may be given because I have to come down from Guwahati.
Okay.
Any date.
Okay, list on, give me a date after 3 weeks. List after 3 weeks on 3 weeks,
16th August.
16, and so on, so, yes.
Item number 2.
Yes,
May I please, my lord? My lord, this is a joint application under 482 of CRPC for quashing and setting aside of Itanagar PS case number 46 of 2012.
okay, will issue notice. I heard Mr.
Omodi.
Learned counsel for the petitioner who has filed this joint application under section 482 of the Code of Criminal Procedure Code for quashing the FIR dated 04/03/2012, registered as Itanagar PS case number 46/2012 under section 341/392 IPC within brackets GR number 82/12 and its subsequent proceedings of the case. Full stop. Issue notice to the state respondent, Mr. So-and-so.
Scan copy of LCR.
Learned additional PP accepts notice on behalf of the state respondent. No need to issue formal notice. Requisite extra copies of the petition to be duly furnished to the learned additional PP. List after 1 week.
Scan copy of LCR.
Okay, meanwhile, scanned copy of the LCR is to be called for. Has it been charge sheeted?
Yes, charge.
Yes.
Okay, is to be called for. Yes.
Obliged.
I will.
Item number 3.
Yes.
Yes, please, my lord. I am for the petitioner and this is the petition for quashing of FIR bearing number 74/2024 under section 420 IPC of PS Naharlam. In nutshell, Janab, complainant and the accused both are the businessman and the accused complainant has booked some item with the accused to prepare of rupees 9 lakhs and out of which 4,50,000 he has already paid.
Okay, we'll issue notice first, isn't it? Then we'll hear the details.
There is my interim prayer, my lord. Kindly consider it. IU concern has issued the notice to join the investigation on 28th of July. So kindly hold the inquiry because I am saying that is the present FIR is a business transaction. There is no criminal antecedent, criminal act.
No, so let the investigation go on. There's no harm in that, isn't it?
My lordship,
You have not paid for any anticipatory bail or anything, so there's obviously no
I am just
danger
wanted
of being you arrested, so there's no harm in letting the investigation go on.
I'm praying for staying the petition. Operation of the FIR. Kindly see in my petition on third page number 2nd of the page. Kindly see my lordship. To hold the proceeding inquiry notice issued by the under IU petitioner under section 35(3) of BNNS for joining the investigation and thereafter for issuance of direction to the IU concerned not to arrest the petitioner till the final disposal of the present petition. If this honorable court issuing the notice on this petition. If this honorable kindly see my petition, then honorable court can realize this is the FIR is bad in law and
Let's see
not.
the FIR, let's see the nature of the FIR.
May I read? My lord?
Are there
FIR
any elements of what, criminal
May I,
act?
may I
noted
read?
out?
my lord? FIR is on page 11 to 13 and on the basis of the complaint which is on the page number 15. May I read? my lord?
Yes.
May I read? Para 1. I have been running a business under the name of Shri Rani Sati Agency. I came in contact with the accused, namely Salil Pandya, mobile number so and so, proprietor of Yuvraj Steel, who is in the business of manufacturing, supplying commercial kitchen equipment. Yuvraj Steel, it's having situated in the Kundli, Sonipat, Haryana. And third para, may I read? As per the terms of quotation were exchanged between the parties and the complainant agreed of our quotation, and out of which 50% amount has been paid. Thereafter, accused prepaid all the items and informed him to verify items and paid the amount. And the accused paid the items and verify the equipment which is ordered by him to the complainant to prepare it. Thereafter, he assured that he will take their items on his own because he need to pay the cartage charges, which is the terms of quotation already mentioned in my petition, and quotation is separately annexed on page number 17. And the last page of the quotation, which is separately mentioned. So to save the cartage charges, it is the liability of the complainant. He has to bring their items which is prepared by the complainant. Still, they are carrying by the accused, and they are covering the spaces, and accused are unable to keep them due to space problem, and requesting again and again the complainant to take them, but he is unable, and thereafter he suddenly illegally demanding that my money is returned, and threatened him that if he is not returned, if the accused shows his inability to return the same, he threatened him to implicate
No,
him
we will
false.
consider and explain this thing, because here, if you look at page 16, it says that you could not be found, you could not be contacted.
No, my
Accused
lord.
is not traceable.
No, my lord. Accused is traceable, and IU has issued the notice recently posted and on WhatsApp. So how can say that he cannot traceable? He is not traceable.
You see, it's based on that they got worried. Huge amount of money has been given to you.
I have already annexed my statement. I have received the amount and complaint paid the entire amount. I don't know what is
Where's your statement? Where's your
reason
statement?
based on to the complainant why he has not taken his items, and rather demanding the money and pressurizing him by registering the present false FIR, etc., and other thing of the threatening acts.
You see, because
Yes, madam.
recently there have been so many cases of
Please, madam.
money being siphoned off, not being paid. And when there are clear elements of section 420 and 506, though you have not been booked up to 506, have been
Yes.
made out. So here also an element of 420 could be clearly made out.
No, my lord, it is a business transaction and purely in the civil nature. Mere contract or breach of contract, there is no breach. I am ready to
Anyway, we'll also
ready to
issue,
give
have
their
you made,
items.
we have to issue
If this
notice. You
honorable
have
court
not,
direct
you have
me, I am
made, you
ready
have
to
not
return
made,
it. GG.
you have not made the complainant a party.
I am mixed. That is respondent number 2.
You have made,
Yes, my lord. Kindly see
but
petition.
in the, okay, but in the cover, it's just state of AP. And another
AP
should be there.
and NL. Yes, my
Yes, so it's who have wrong, we didn't, okay. So the complainant will have to be issued notice also. Then
Yes.
maybe we'll fix a short date, then Let the complainant also be represented.
My humble prayer to stay the proceeding till the order of the honorable
Okay,
court.
heard Mr. So-and-so. Learned counsel for the petitioner. Who has filed the instant application under section 528 of the Bharatiya Nagrik Rashtra Sandhya, 2023 for quashing of FIR bearing number 74/2024 dated 15/07/2024 under section 420 IPC within brackets under section 318 BNS, 2023, registered at PS Naharlagun and the proceedings emanating therefrom. The learned counsel has further prayed that the proceedings / inquiry inquiry notice, okay, issued by the IO to the concerned petition under section 35 within brackets 3 of BNSS be stayed till the next date of listing. Issue notice to the respondents, Mr. So-and-so, learned additional PP, accepts notice on behalf of respondent number 1. Notice is to be issued to respondent number 2 through registered post with AD within 3 days, returnable by 3 weeks. List on, do you want a date?
Appropriate to this one for my lord, please.
After 3 weeks on a date to be fixed by, make it 2 weeks. Okay, after 2
Oh.
weeks on a date to be fixed by the registry.
Your Lordship, my query is that whether investigation is stay or
What?
investigation was stayed or in this case, I have objection regarding the stay of
No,
investigation.
we have not passed any order concerning that.
Yes,
So you want to object?
After registration of the case, it cannot be.
The learned counsel for the learned additional PP has strongly objected to the stay of the proceedings / inquiry notice issued by the case IO concerned to the petitioner, submitting that he may be given time to get instructions in that in the matter. In view of the above, the prayer for stay of the proceedings / inquiry notice issued by the IO to the petitioner. To stay the proceeding and is to be considered in the next returnable date.
My lordship, please,
All right.
it is only already issued on 28th of this month. Kindly issue, मैं जनाब next date तक के लिए ही कह रहा हूँ, please.
Nothing is going to happen next returnable now.
He
After
is
2
residing
weeks, you will
Sonipat,
consider.
entire thing on available on record, my lordship. Kindly consider.
We'll
Please stay
consider
till
the
the
whole
next
thing in the next date, okay, yes.
Pavla, Your
Item 4.
Your Lordship, I'm appearing on behalf of counsel for the petitioner, K lawyer. Here, we need some more time to file rejoinder.
Okay. Mr. So-and-so appearing on behalf of Mr. So-and-so. Have you got the name? Learned counsel for the petitioner. Is it?
Rejoinder.
Rejoinder?
Yes.
Has prayed for further time for filing of the rejoinder affidavit. In view of the above. Is it affidavit in, okay, in view of the above, list after 2 weeks.
3.
Okay, 3 weeks on a date to be fixed by the registry. Yes.
Item number 5.
May I,
Yes.
Your Lordship? Your Lordship, on the last occasion, they have, the respondent, they have filed the affidavit, Your Lordship. And for the same, I have prayed that we would be filing rejoinder. However, we would not like to file the rejoinder and then matter may be fixed for admission hearing, Your Lordship.
Okay, heard, Mr.
Jezreel.
So and so, learned counsel for the petitioner along with Mr.
T Dolo on behalf of Entache.
T. Dogan, appearing on behalf of so and so, learned counsel for the respondents. The learned counsel for the petitioner submits that they will not be filing any rejoinder affidavit and that the matter may be listed for admission hearing.
Your Lordship, there is an interim,
Accordingly, list for interim, for admission hearing after 2 weeks. Meanwhile, interim order passed earlier shall continue till the next date of list.
obliged, Your Lordship.
Item number 7.
My lord. My lord. In item number 4, there was an interim. Item number
Okay.
4.
For interim order passed earlier shall continue till the next.
What?
Then, what about 6? 6 we dispose of?
Lordship, in item number 6, there's interim order. I'm for the
6?
petitioner.
Have we passed an order? Okay. We have a passed order? No. Yes, 6.
Here, my lord,
Item number 6.
6. 6, yes, my lord. My lord, here, my lord, I have instruction, my lord, not to file counter affidavit, my lord. So, my lord, matter may be listed
Let's see.
by,
In item number 6.
yes, my lord. I am for respondent on it.
Okay.
my lord.
Heard Mr. So and so, learned counsel appearing on behalf of Mr.
For petitioner, I'm S. Zirang.
S. Sirang, learned counsel for the petitioner,
Yes.
along with Mr.
L no C, my lord.
L. Longi, appearing on behalf of,
Respondent number 1 and 2, my lord.
your name is there?
Yes, my lord.
Okay, appearing on behalf of respondents number 1, no, learned counsel for respondents number 1 and 2.
Yes, my lord.
The learned counsel for the respondent submits that they will not be filing any counter affidavit. Okay, so how many respondents are there? 1 and 2 will not file counter affidavit. Then any other respondents?
There's only 2
Yes,
respondents.
3 and 4.
3 and 4.
None appeared for respondents number 3 and 4. The AD card of service upon respondents number 3 and 4 has been filed. We may give an opportunity for respondents number 3 and 4 to be duly represented. List after 3 weeks.
Lordship, interim order.
In the
Interim.
meantime, interim order passed earlier shall continue till the next returnable date. Yes.
Item number 7.
Lordship, in item number 7, I'm appearing on behalf of B. Picha for petitioner. We have
Okay, who's for the appellant?
dusty service has been served. Lordship. Dusty service has been served.
You are for the,
Petitioner
so.
in
okay,
item number
appellant,
7.
Appellant, okay.
Yes.
Let me see, where is it? Is it duly signed by the respondents? What's the name of the respondent?
Lordship,
What is the name of the respondent?
Lordship, I don't have the brief, Lordship. I have been instructed by,
No, because someone has signed. Let me see, there's something wrong there. What is this court's order? Notice upon respondent is complete, okay? Then notice upon respondent was complete long time back,
yes.
isn't it? Anyway, Mr. So-and-so appears on behalf of Mr. So-and-so, learned counsel for the petitioner, while none appear for the respondents. In view of the above, list after
1 week,
3
Lordship.
weeks,
1 week, Lord.
after 2 weeks.
Item number 8.
Lordship, I'm appearing on behalf of M. Kato for the private respondent. Leading counsel is out of station.
Yes, you are for the,
Respondent, private respondent.
who is for the appellant?
For the petitioner, ma'am. My lord, I'm for the petitioner, sir.
Appellant, you have applied as appeal, not, we have not heard, so. Mr. So-and-so, learned counsel for the appellant is present along with Mr.
L. Rakap,
So-and-so, appearing on behalf of his senior Mr.
M. Kato, Mathur.
M. Kado, learned counsel for the respondents. The parties for the learned counsels for the parties have prayed for adjournment.
Deeply obliged.
In view of the above, list after 3 weeks.
Obliged.
Item number 9.
My lord, here I'm appearing for the petitioners, my lord. Here the respondents have already filed the affidavit. So may I pray, my lord, this may be listed after 4 weeks so that if necessary, we will file our rejoinder.
Okay, heard Mr.
D. Soki, my lord.
So D. Soki, learned counsel for the petitioner. Along with Mr. P. Tajo, learned counsel for the respondents. The learned counsel for the petitioner has prayed for adjournment of 3 weeks,
4 weeks, my lord.
of 4 weeks. And submits that in the meantime, they will be filing the rejoinder affidavit if so advised. Accordingly, list after 4 weeks.
Always.
Item number 10.
May it please your lordship. Well, this is an anticipatory bail application. The petitioner is on interim manner. There is a direction from the court to appear the petitioner before the IO, my lord, within 7 days, my lord, within a week, my lord. But my lord, petitioner is suffering from right knee pain, my lord. It is called chondromalacia grade 3, my lord, stage grade 3. So, my lord, he could not proceed to my lord Bhalupong to record his statement. Medical certificate the ladder fan has furnished, my lord. So, my lord, it is a, my lord, matter pertains to my lord non-payment of some, my lord, bills hired by the company, my lord. Petitioner, he is the,
Medical certificate, huh?
my lord, he is the
Yes.
CMD of the company, my lord. So, my lord, accounts personnel may be allowed to, my lord, appear before the IO and they will produce the accounts, my lord. Account related, my lord. There is discrepancies in the bills and some unpaid bills,
420.
my lord. It is a civil, purely civil nature, my lord, non-payment of my lord bills, my lord, hired by the vehicles hired by the company, my lord. So, my lord, lordship may make it, the interim may be absolute.
CD,
Your Lordship, we have received the CD, Your Lordship.
Hmm.
My only ground with regard to the CD is that a non-bailable warrant of arrest was issued on 2/2/24, Your Lordship. That has not been disclosed in the petition, Your Lordship.
No,
By
that is
the
not received by
because on 16/7/24 the matter has come up, Your Lordship. Your Lordship will see under section 70 clearly says that if non-bailable warrant is issued, Your Lordship, only if the execution of the non-bailable warrant is executed or is recalled by the court who has issued, that's when the non-bailable warrant will be cancelled, Your Lordship.
My lord, actually, he has no knowledge of
Now,
any
so
non-bailable warrant.
where's the non, in the CD?
CD, Your Lordship.
Where is that?
I have flag marked the CD, Your Lordship.
Ah,
The next page to the flag mark. Next page to the flag mark, Your Lordship. Now, Your Lordship, they ought to have also disclosed about the non-bailable warrant, because if that is the case, Your Lordship can pass an interim stating that he be appeared on the next date when the non-bailable warrant date is given for his appearance, Your Lordship.
so when is the date given?
Not given, Your Lordship. It has not been annexed, Your Lordship.
Then?
Only reference, and in the CD it is there.
Then how can we pass an order that he should, when is he supposed to appear? This was issued on
2/2/24, Your Lordship.
2/2/2024.
It has not been executed till date, Your Lordship.
So when is the date for execution? For the date for production?
Production. After execution only he will be produced, Your Lordship. No certain
So-
date as
so,
such.
But there should be a date fixed by the learned court as to when.
Yes, Your Lordship. Therefore, I was submitting that, if I may read, Your Lordship, every such warrant shall be remain in force until it is cancelled by the court or court which issued it, or until it is executed. So if it is executed by the police, it will be cancelled, and they can also approach before the honorable trial court who has issued the warrant for cancellation of the same, Your Lordship.
That is another aspect, my lord. Lordship may, I am on, my lord, 438, my lord, CRBC, my lord, seeking pre-arrest bail. So, my lord, Lordship may allow the, my lord, my
So,
prayer, and
then we
Y
will-
part, my lord, will approach the court below, my lord.
Because a non-bailable warrant has been issued.
So
Your
a
Lordship.
non-bailable warrant has been issued. Obviously, anticipatory bail is also concerning non-bailable offences only,
Yes,
isn't
right.
it? So you, since the interim bail has been granted, and now we have to dispose of the final anticipatory bail application. So we'll make it absolute, and then on the event of arrest, he will be
My lord.
granted bail with the same terms and conditions which have been imposed
Yes.
by this code by 16/07/2024, isn't it? Yes, heard Mr. J.C. Gogoi,
Gogoi.
is it? Learned counsel for the applicant, along with Ms. So-and-so, learned additional PP for the state respondents. It is seen that the petitioner / applicant was granted interim pre-arrest bail by this court's order dated 16/07/2024, and today has been fixed for the final hearing and disposal of the bail application filed under Section 438 of the CRPC
Lordship, Your
in
Lordship.
connection with Balokpung PS case number 19/2023 under sections 420/406 of the IPC. The learned counsel for the applicant / petitioner submits that the petitioner.
Your Lordship, if I may interfere, Your Lordship. Your Lordship, because since the file did not have that he had gotten interim, Your Lordship, there is also a statement by the IO that he has never come for his giving his statement, Your Lordship.
So
the
interim is in the event that he comes and then there's a requirement to arrest him, then he will again immediately after that be granted bail, isn't it? So he has never applied, the learned counsel for the petitioner submits that the petitioner could not appear before the case IO on the date fixed, is it, for his appearance? When was it?
Hello, it was within a week, madam, from 16.
On the dates fixed for his appearance, since due to his medical condition, a copy required and
Your
submits
lordship,
and has submitted the medical certificate issued. This is not a government hospital, isn't it? Issued by a Dr.
Prasad.
B.M. Prasad.
Your lordship, that medical certificate was given to us, your lordship.
Okay.
We had given them time to appear again, your lordship.
Oh.
Thereafter, we went to his resident, wherein it was informed that he's presently all right, and he has gone to Dibrugarh to attend his relative's funeral, your lordship. Thereafter, again we went, and then it was informed to us that he had gone to Mumbai. That's the information given in the.
So is he in Bombay right now
Yes, my lord, he is in Mumbai, my lord, for his treatment, madam.
for treatment?
Not treatment, your lordship.
Is it
I
for
have not-
treatment? He
Treatment.
can't just roam around when he has a case.
Actually, my lord, he has some knee problem, my lord. It is a critical stage, my lord. It is grade 3 stage, my lord. So, my lord.
Okay, here's this thing. Now, this medical certificate has been issued from which place? This is Assam. So why
No,
is
it
he
is
in
Assam.
Bombay? Why is
Assam.
he in Bombay?
No, it is issued in Assam, my lord. No, he is in Assam, my lord, not in Mumbai, my lord.
I'll just show the CD, your
He is
lordship.
in
Well,
Assam,
we-
right?
But the CD mentions that he's in Bombay.
yes.
No,
Where?
no. In Bombay, my lord, it was earlier, my lord.
Your lordship, I'll just show the.
My lord, it was 1 month ago, my lord. He was in Mumbai.
Okay, anyway, Dr. So-and-so dated 24/7/2024. The learned counsel for the petitioner has thus prayed that the interim bail previously granted by this court in its order dated 16/07/2024 may be regularized and the petitioner may be granted bail, may be allowed to be released on bail in the event of his arrest during the pendency of yes, in the event of his arrest. Miss so-and-so, Jeannie, learned additional PP, has brought to the notice of this court that even though the petitioner is said to be having medical problems, a perusal of the CD reflects that the petitioner had traveled to Bombay to attend some wedding.
Dibrugarh, he had gone
He
to
had
Dibrugarh.
first gone to Dibrugarh to attend a wedding on, when was it?
The date is.
Okay, to attend a wedding during the pendency of the matter, and thereafter had gone to had traveled to Bombay.
That was informed by his legal advisor of the firm, Your Lordship. Of
As
which he is the director.
Informed by the legal advisor of the firm. Mr. So-and-so, learned counsel for the petitioner, submits that this traveling of the petitioner was a month back, you're saying, is it a month back?
Not after the issuing, passing the interim order, my lord, before.
And not during the passing of the interim
Interim order.
order. With just before that, learned PP, okay, learned additional PP submits that the contents of the CD shows that the petitioner has not been cooperating in the investigation of the case and that he had traveled to Dibrugarh. Continue with that, okay, and Bombay. Yes, the report in the CD is that you are not cooperating with the
No, my lord, actually,
investigation
my
of the
lord,
case.
that was my lord Dibrugarh, traveling to Dibrugarh and Mumbai, my lord. It was prior to my lord this order, and it was before 1 month, my lord. When
And
police
it is
did
because of your non-cooperation that a
No, my lord, he is ready
non-bailable
to
warrant
cooperate,
was
my lord.
issued.
My lord, he will be ready to cooperate, my lord. As soon as he get well, my lord, he will, my lord, he will, my lord, approach the IO, my lord, to record his statement, my lord.
Yeah, just continue with, okay, before learned counsel for the petitioner, you just mentioned that since the petitioner had not been cooperating with the investigation of the case, a non-bailable warrant was even issued against the petitioner. Full stop. Then after that, Mr. So-and-so, learned counsel submits that he had traveled before the issuance of the whole thing. What is the last sentence? Just read.
When it comes to the mechanism that is traveling of the was a month back and not doing.
So he further submits that he will be fully cooperating with the investigation of the instant case. Full stop. Having heard the submissions made by the learned counsels for both the parties and on perusal of the nature of the FIR filed and the fact that the petitioner has been charged under 420/406 IPC. This court find it fit to grant anticipatory bail to the petitioner under section 438 of the CRPC with the by regularizing the interim bail granted to the petitioner whilst this court's order dated 16/07/2024 with the same bail bond and conditions imposed by this court earlier. Accordingly, so-and-so stands allowed and disposed of.
Your Lordship,
Yes.
only one small request, Your Lordship. If Your Lordship could mention the non-bailable warrant issued on 2/2/24, which is yet to be executed, Your Lordship.
So the non-bailable warrant, if they will try and execute, they will
Yes,
go to arrest him. then because of this anticipatory bail, he will be granted bail with the
Yes,
same
only
conditions.
that reflection, because they have not brought it to your lordship's notice since the bail was moved on July and the non-bail warrant was already issued in the month of February. Only that
Oh.
reflection, your lordship.
Okay, it may be noted that the non-bailable warrant of arrest already issued against the petitioner on
2/2/24, your lordship.
2/2/24. What?
And they have filed this on 16/7/24 and they had not
Was
disclosed.
already issued on 2/2/24 and the instant anticipatory bail application was filed on
16/7, moved on 16/7/24.
16/7/2024. In view of the above, the non-bailable warrant of arrest issued should be what?
No,
What
your
was-
lordship, my only prayer with regard to those two dates were that they have not disclosed it before this honorable court. Your lordship.
Okay, we'll mention that in the
Yes.
listing. That is not really a big. In the submissions made by the PP, additional PP, okay? Before the learned counsel for the, you can mention that, okay? I had also brought to the notice of the court that so and so and so, yes.
Deeply obliged.
Highly
Are you
obliged.
getting it? Yes. Dispose, allowed and disposed, yes.
Highly obliged.
Item number 11.
Yes, what is the state?
My lord, the earlier counsel for a respondent has withdrawn their wakalatnama.
So now you are Mr.
M. Doji, ma'am.
M. Doji. So in the last court date also, you had prayed for time to take steps for service of notice. You have not taken?
I have taken, my lord.
Okay, so then we'll have to await. But in this office
Yes, ma'am.
note dated 24/07/2024, it says that the counsel for the petitioner has not taken steps for issuance of notice upon the respondents.
My
That
lord,
was dated 07/05/2024.
then I may be allowed to take precedence.
Why are you taking so much time? Within 1 week, you'll have to take steps.
Yes, ma'am.
Mr.
My lord, I may,
What?
that's the service may be allowed.
No, no. Unless you take steps first.
Yes.
Then if it cannot be served or something happens, then that's the service will be allowed. Without taking steps straight away, how can you do it? Isn't it?
Yes, ma'am.
Heard Mr. So-and-so appearing on behalf of Mr. M. Doji, learned counsel for the petitioner. It is seen in the office note dated 24/07/2024 that the learned counsel for the petitioner has yet to take steps of service of notice upon the respondents. The counsel for the petitioner is to take steps for service of notice upon the respondents positively within 1 week, at least after 2 weeks. After 3 weeks.
Obliged.
Item number 12.
Yes.
Lordship, in this case, earlier the petitioner counsel was engaged. Their personal problem, case could not be continued. On the request of the petitioner, I have filed an additional wakalatnama for the petitioner.
Okay, so you're going to represent the petitioners?
Yes. So I have no any records regarding this case. Your Honor, some time may be given for the
Okay.
further procedure.
Heard Mr. So-and-so, learned counsel for the petitioner, who submits that you have filed a wakalatnama?
Yes, earlier.
He has filed his wakalatnama and will be representing the petitioners Petitioner or petitioners? The petitioner. in this
Petitioner.
case, Yes. He further submits that he has yet to collect the required documents in the case. We prayed for adjournment. In view of the above, list after
3 weeks,
3 weeks.
Yeah. much or less.
Survey has not completed.
Heard Mr. Heard Miss Diriba. Appearing on behalf of Mr.
SK Dury.
SK Duran, learned counsel for the petitioner, along with Miss So-and-so, learned additional PP for the state respondents. It is seen that the service report upon respondent number 2 is still awaited. In view of the above, list after 3 weeks. List after 3
Your
weeks.
Honor, I may be allowed to make a prayer to take a fresh step, Your Honor.
Okay, is still awaited. In view, on the prayer made by the learned counsel for the petitioner is allowed to take fresh steps upon respondent number 2 through registered post with AD within 3 days, returnable by 3 weeks. List after 3 weeks. Yes.
Lordship, here the service upon all the respondents completed.
So who's for the respondents?
Respondent number 1 is appeared on 1/3/2023, Lordship. However, thereafter, Lordship, they didn't make any appearance till date. Because of which this delay application is still pending. Lordship, may I pray that on the next date, Lordship, if the respondent does not appear, Lordship, the delay application may be considered.
All there is notice is complete.
Yes,
2 and 3. Who is 1?
1 is the claimant.
Okay. Heard Mr. Your name is there?
Yes, the time.
Heard Mr. So-and-so. Learned counsel for the applicant. It is seen that notice upon the respondents is complete. However, none have appeared on behalf of the respondents. In view of the above, list after 3 weeks. It is noted that if the respondents remain unrepresented in the next date, this court may pass appropriate orders. Yes.
Yes.
If the respondents still remain unrepresented.
Made with your lordship. Lord, this is a 439 subclause 2 petition, your lord. The petitioner is the informant. The matter pertains to section 376 IPC, my lord. So, my lord, this was, my lord, initially, Honorable Sessions Court rejected the bail prayer of the accused person. Then Honorable Court allowed the accused person's bail prayer, and challenging that, my lord, the informant went to the Supreme Court. The Honorable Apex Court, my lord, granted liberty to file, my lord, cancellation of bail before this Honorable Court. The ground for approaching the Honorable Court is that, my lord, the conditions which were imposed upon the accused person, that he should not intimidate the victim or the witnesses, my lord, that has been violated, and that was the, my lord, ground taken in this particular case. But, my lord, this matter is of, my lord, July 2022. And the investigation must have been complete also. I don't know, my lord. So, my lord,
Okay, charge sheet has not been filed in the case.
that I don't know, my
We
lord.
don't know.
Maybe
Okay, so you want to pray for adjournment? Find out what is the status of the case.
because if
That's it.
charge
In
sheet
fact, in
is
this
submitted.
case, the respondent number 2
the
Uh,
notice was issued.
uh,
And as of now, whether the notice has been served or not,
The
that is
victim
one
or the
part.
victim, the
My
victim in the instance.
Victim is
case.
the petitioner, my lord.
No, my lord,
Okay,
the
victim is the
accused,
petitioner, so
accused,
respondent number
accused.
2 is the
Accused,
accused.
accused, my lord.
Okay,
So if charge sheet is submitted, my lord, then the matter is pending for trial, then this
so
petition will
you're
become
appearing
infractuous.
on behalf of
state, my lord.
state.
Special
Okay,
PP is also
Special
there
PP
for
SIT.
SIT, my lord.
My lord, at this stage, instead of verifying the status of the case, my lord, a notice
Notice
be
has to
completed
be
first. my lord.
complete upon the respondents. Both the respondents. Because both the respondents, isn't it?
One respondent, my lord. The other is state
Uh.
of Arunachal Pradesh, my learned friend is appearing. And the other one is, my lord, the accused person. Page
Okay,
3, my lord.
respondent number 2.
2, my lord.
Heard Mr.
MK Das, my lord.
M.K. Das, learned counsel for the
Petitioner.
this is an applicant, isn't it?
My lord.
Learned counsel for the applicant along with Mr. So-and-so, learned PP.
SPP,
is it?
man, SPP
What?
SIT.
SPP, SIT for respondent number 1. Have you taken steps?
My lordship.
It is seen that though the learned counsel for the applicant had taken steps for issuance of notice to respondent number 2. Return of service of notice upon respondent number 2 is not received till date. In view of the above, we may await for return of notice upon respondent number 2. List after.
Because, my lord, the last order was passed, my lord, quite some time. Lord,
You want to issue fresh notice?
that will be my lord,
Okay.
my prayer.
It's not returned till date. The learned counsel for the applicant has prayed that they may be allowed to issue fresh notice upon respondent number 2. Praise allowed.
In the meantime, my lord, if a report comes, my lord, because if charge sheet is submitted and trial has already been started, then my petition will become infractuous. And that will be the subject matter of my lord honorable
praise
trial
allowed.
court.
Okay, after praise allowed, the learned counsel for the applicant / make it petitioner, okay, further submits that a report of the present status of the case may be furnished by the learned special PP, since if a charge sheet has already been filed, the instant application may also become infractuous.
My lordship.
In view of the above, the learned special PP is to do the needful list after.
My lord, can it be on 8, my lord, because only a report, my lord, matter of.
And also
Eight.
notice, okay,
Notice.
in the meantime, okay,
Eight.
let's on 8/8/2020.
Deeply obliged, highly obliged.
Highly obliged.
Yes. Now, the office note dated 24/7/2024 reflects that service of notice upon respondent number 2.
My lord, here I will be appearing for all respondents.
You were supposed to take steps, the petitioner was supposed to take steps.
Well, I'm entering appearance, my lord.
For
On
respondent, for all the respondents.
all the respondents.
Okay. So what is the stage? What are we supposed to
My lord,
do?
let this be listed for admission hearing, my lord, on the next.
Okay. Mr. So-and-so, heard Mr. So-and-so, learned counsel for the petitioner, along with Mr. So-and-so, learned counsel for all the respondents. The learned counsels submit that this matter may be taken up for admission hearing. In view of the above, list for admission hearing on, after 2 weeks,
My lord,
on a date fixed by the registry.
My lord.
Yes, anything you want to submit? Huh?
Yes, my lord, interim may be continued, ma'am.
Meanwhile, the interim order passed earlier shall continue till the next date of listing.
May I please, Lordship?
Yes.
Lordship, this is a criminal appeal filed by the appellant challenging the impugned judgment and sentence dated 16/8/2023 passed by the learned Special Judge Pokso Pasika.
Yes, but she has to be represented, respondent number
Yes,
two.
Yes,
So we'll have to wait. The steps were supposed to be taken.
we have already taken a step on the last date.
Okay. That was last month, so we'll wait for some time. Where's the address? She's from which place?
It's
Somewhere close by or some far flung
it's
village?
not so far. It's in lower Siang district. It's nearby only. 2 weeks.
Okay. Heard Mr. So-and-so, learned counsel for the applicant slash appellant, along with Ms. T. Genie, learned additional PP for the state respondents. It is seen that notice upon respondent number two is not returned till date. We may await for return of service of notice upon respondent number two, list after 2 weeks on a date to be fixed by the registry.
Deeply obliged.
Your Lordship, on item number 18, Your Lordship, if I may kindly request this court to take the matter on Monday, Your Lordship. The issue in this case is that a complaint was filed against the accused, Your Lordship. During the process, when the proceeding was held, Your Lordship,
Yes.
the informant had in fact, it was revealed to the court that informant had in fact filed a false complaint against the accused, Your Lordship. The accused was acquitted and the complainant was then made an accused by the court below and had convicted under her admission under section 22 of the POCSO Act, Your Lordship. And that's what the challenge is of.
Okay, false information. Is
Yes,
that-
false information. My lord, here in this case, FIR was lodged by the CWC, Child Welfare Committee, SAPA. The present convicted person is illiterate woman, and entire
But
information
he was
is given by the
but
victim.
wait, this point you'll have to explain then that the accused was convicted. If the accused was convicted, that means the victim must have deposed before the court.
No, the accused was not acquitted.
No, the victim. The victim must have deposed before the court.
164 statement, she clearly admitting that the entire fact was narrated by her only, and false information was narrated by her only victim. So in that case, section 22 POCSO for a child, there is no such.
I heard Mr. So-and-so, learned counsel for the petitioner.
MK Das, my lord.
Yes.
In
MK Das.
this particular case, my lord, only aspect is because on the last occasion one report came up as part of, my lord, the submission of the learned PP, and my lord, the charge sheet was submitted. But the only question is, my lord, whether charge sheet, my lord, has been submitted against the main accused person, and whether this particular petitioner has been, my lord,
Okay,
sent up.
because there's a co-accused in this, who's the main?
My lord,
And
one
you're the
main accused
co-accused.
person.
Okay.
Only, my lord, I have been implicated in this particular case on the strength of a
get
41 in
copy
notice.
of the charge sheet also, whether we'll see then in the copy of the charge sheet,
My lord.
whether you have also been charge sheeted against
My
or
lord,
only
if
the main.
not sent up for trial, my lord, then, my lord, with that observation, honorable court can dispose of this particular case, my lord.
No,
Lordship, today, Lordship, may Lordship, this criminal petition they have filed regarding the issuance of the 41A, they have noticed, Lordship. And that notice, Lordship, according to the last occasion, Lordship, I have produced the CD. According to that notice, after they receiving that Lordship, they have already appeared before the IO. Their statement also been reported. So this
okay,
why
anyway,
this
nothing
criminal
is going
petition
to
has
happen.
filed.
We will wait for the
Yes, sir.
updated CD, then everything will become clear, isn't it?
lordship.
But
With
Mr.
honor,
MK Das,
limited prayer, my lord. Whether, my lord, this particular accused person has been charge sheeted or not, my lord.
Okay.
Limited prayer.
Heard,
But that will also charge sheet will also
Mr.
take it, yeah.
MK Das, learned counsel for the petitioner, also heard Ms. L. Hague, learned additional PP for the state respondents. It is submitted by the learned additional PP that since the case IO is on leave, she could not obtain the updated case diary and has prayed for further time. Mr. M.K. Das, learned counsel for the petitioner, submits that he has been informed that the main accused in the instant case has been charge sheeted and prayed that information may be also called for whether the instance petitioner has also whether a prima facie case was also found against the instant petitioner and whether his name has been included as an accused in the charge sheet. Isn't it? Yes.
Not, my lord, with regard to the prima facie case, my prayer is whether he has been sent up or not sent up for trial. If he has not been sent up for trial, then.
No,
my lord,
if
end of
your
story.
name is in the charge sheet, he'll be
That-
sent up for
that-
trial. So
my
what we
lordship.
want to know whether your name has been included in the
In a
charge sheet
charge
or not.
Limited
isn't
prayer,
it?
my lord. Yes, my lordship.
In view of the above, the learned additional PP is also to furnish the required information, whether as noted above. Okay, list after
2 weeks, Lordship.
On,
2 weeks.
may I pray, my lord, on 8th, my lord, because, my lord.
No, it
I'll
may
be
not be
coming from
possible because they
Guwahati
have gone
for-
to Lordship in
No,
other state.
but since the what case IO is on leave, is said to be on leave on 8th, again the same issue may be there, isn't it? So when will you be ready?
Lordship, after 2 weeks,
I
Lordship.
can, my lord,
weeks,
because
give us a
one
date.
matter, my lord, I'm coming from Guwahati for one matter.
So
Today it has been fixed
you
on
have
8th.
to, we cannot jungle
May-
the court as per
may-
your convenience.
Absolutely, my
Uh-huh.
lord, absolutely, that is correct, my lord.
So list after 2 weeks, give a date. Any date. So 2 weeks is 9, so 8 and 9 very close by, so list on 8.
Eight,
lord,
eight, Lordship, then.
Hmm.
My lord,
Is it
deeply
8?
obliged,
List on 9, 8, 2020. Yes.
deeply obliged. 9, 8. Can it be on 8, my lord?
Okay, on 8, 8, 1 day difference doesn't make a,
Highly
8,
obliged.
8. 20.
Deeply obliged.
Yes. What is this?
Last order, Lordship.
Hmm.
I have been given direction to this amend the course title. But
Yes.
this matter is, this direction was passed because this respondent number 6 is no more important because we have settled the matter. This is with regard to land compensation matter. With regard to respondent number 6, we have settled.
Okay,
Personally,
so not required to be arranged.
yes.
So
that
cost
is why-
title, this thing?
Yes, that is
Amended
why,
cost title?
yes,
Yeah.
that is why direction was passed for
Yes.
this amendment. But this petitioner is very staying at the Tooting area. That is 2 days journey from here.
So
That
you
is
need
per-
further time?
This is no lordship. At least stays. I may be allowed to withdraw this case. We did liberty to file fresh.
Okay. Yes, heard Mr. T.
Yeah, Tapak.
T. Tapak, learned counsel for the petitioner, along with Mr. So-and-so, learned government advocate. Is it? Appearing on behalf of the state respondents. The learned counsel for the petitioner submits that since respondent number 6
Yes, that is
is no
settled.
longer arrayed
Yes.
in
Respondent.
the instant writ petition, he may be allowed to withdraw the instant writ petition with the permission to file afresh, if so advised. In view of the above, the instant writ petition stands disposed of on withdrawal with the permission to file afresh. Yes. Yes, what is the
May I
matter
plead the
about?
lordship? Here, I am being aggrieved by the impugn eviction order of the learned Deputy Commissioner Sanglang. So here, Lordship, the fact of the case is that I have occupied a plot of vacant land way back in 2009. And the land in question was not at all fit for human habitation. And after my occupation and possessing the land in question, I have developed the land in question, and I have constructed kacha house and settled there for more than 14 years. And after settled down there, the dispute at the land in question for 14 years, I have been served with a so-called notice issued by State Officer cum ADC Changlang. And in response to that, I have submitted my reply, submitting my documents, and waiting for a hearing date to be fixed. But in a very mechanical manner, without hearing me, without affording me a reasonable opportunity of hearing to contest my case, an eviction order was passed. And eviction order was passed to the effect against the said eviction order. I have filed an appeal before the affiliate authority, that is the Learned Deputy Commissioner, who is the affiliate authority in the district. So the Learned Deputy Commissioner fixed a date for hearing, but in the scheduled date of hearing, Learned Deputy Commissioner was out of station. And after waiting for 2.5 hours, again another order comes up, deferring the time. That is, it first was on 11 a.m., then it was again deferred to 3:30 p.m. Then accordingly, along with, I have appeared before the Learned Court, but Learned Deputy Commissioner failed to turn up. Accordingly, I have submitted my application for of attendance and sought another appropriate date. And accordingly, because I have to go all the way from Changlang to Itanagar, so I left the court in the late evening hour. Then in the next morning, after 2 days, Learned Deputy Commissioner on the same date, that is on 10/10/2023, an ex parte eviction order was passed without hearing me. Then to that effect, I approached this honorable court by way of writ petition. And accordingly, this honorable court has disposed the writ petition by setting aside the impugned eviction order, ex parte eviction order. And accordingly, the matter was remanded back to the Learned Deputy Commissioner, who is the respondent number 2. So with a direction to hear the matter, for hearing of the matter on 23rd of this month. Accordingly, I have attended the hearing of the Court of Learned Deputy Commissioner on 23rd/7/2024. So wherein the Learned Deputy Commissioner, who is the affiliate authority, while hearing the matter, it was found the respondent number 2, who is the state officer, who passed the impugned eviction order, against whom the appeal was prepared before the Learned Deputy Commissioner, he was absent, nor his representative was there. And another respondent number 4, who is the respondent number 4 herein, who is the district medical officer. So he was also not present in the hearing. So I have pleaded and made a prayer to the Learned Deputy Commissioner that without hearing the complainant or the respondent, both the respondent, they were absent. Intentionally, they keep away absent. Then thereafter, I have requested the Learned Deputy Commissioner to kindly to place the record which has been placed be perused, but it was found while hearing the matter, there is no record. As I have insisted the record to which I have submitted before the appellate authority, the file, even the file was not there in the court. No file, no record, no reference, nothing. And accordingly, the hearing proceeded. And I submitted my points. And I referred the records, but he fails to turn up his file because there is no file in the court. Only a small sheet of paper he was holding. And he was insisting me not to deliver or argue the matter at length. I said, I have pleaded, unless the fact is elaborated, law point is elaborated, how come this honorable court could reach at a amicable decision, a better decision? So therefore, without application of mine, this impugn eviction order has been again passed by the learned Deputy Commissioner without application of mine. So therefore, my submission would be, my prayer is, limited prayer is that since the learned Deputy Commissioner, without hearing the other party also, whose presence and whose pleading and argument was very much necessary, it was mandatory and necessary to hear them. So both the respondent, they were absent. Intentionally, they got the order. They knew the scheduled date of hearing, but they intentionally remained absent. So it is a predetermined eviction order. Even he was not ready to listen to my argument also. So therefore, my submission is that since the learned Deputy Commissioner has failed to exercise his power vested upon him and failed to appreciate the evidence placed on record, because he never brought the file before the court while the hearing was on, nothing of sort. And this eviction, this impugn eviction order, that is, Your Honor, at page 37, is the impugn eviction order, and it contains 9 pages of the order, eviction order. And this eviction order was passed within a half an hour, 1.5 hours. Can it be possible? It was a pre-prepared eviction order before hearing the matter in question. Therefore, my submission would be
Now,
this.
what is your prayer?
So,
What is your prayer in the instant petition?
so therefore,
For
my
remanding the matter back.
Lawsuit.
It is for remanding the matter back to the Deputy Commissioner, is it?
Yes, Your Lordship, that can be done, Your Lordship.
Is that your prayer? You come to your prayer portion.
Yes, my prayer is to set aside and quash the impugn eviction order. And pardon, my prayer would be, since repeatedly the learned Deputy Commissioner is passing eviction order, I am not expecting any justice will be done. Again, if it is referred back to the learned Deputy Commissioner, no doubt he is the appellate authority. But my prayer would be, it should be taken up by other executive magistrate before executive magistrate, maybe take it, direction may be issued to take up the matter. Because until and unless that is so, because learned Deputy Commissioner, he
so
himself is the
yes.
appellate authority, as well as the Deputy Commissioner who is the district administrator. They are
Then
involved.
I think we have to issue notice so that the said Deputy Commissioner will have some say in this matter.
May I
Okay, we
take Your
cannot
Lordship to
pass, huh?
page number, Your Lordship, 31. This
Ah,
with
page?
31,
31.
Annexure 5, Your Lordship. This is a joint inspection report, Your Lordship. Why this land is being required by the government is, it is the government land only. Why it is been required? Because we are making a shortcut to the district hospital, Your Lordship.
Mhm.
And in that process, as per this report, Your Lordship, yes, couple of government quarters are also will be demolished, Your Lordship.
Hmm.
And without having any valid allotment paper, Your Lordship,
You have any documents to show that the land in question belongs to you?
Lawsuit.
Do you have any documents to show
I
that
have, I
the
have
land
submitted
belongs to
my,
you?
I have submitted for regularization of the said plot of land.
Which is not
But-
allowed.
But even the application form was denied to me. Since there was no alternate remedies assessed, to the effect, I have submitted a plain application before the learned deputy commissioner, deed and deputy commissioner, for consideration of my plot, because I being a local tribe, local
Okay,
indigenous.
this thing is that he's been occupying that place for the past 14 years. And so he's trying to claim his right over the land for the
Yes,
past
may-
14 years. So let's see, you issue your, will issue notice. first?
Notice may be issued, Your Lordship.
No, will issue notice, then let's see what you have to say.
Lordship, may the interim may be granted, unless interim is granted, it will become infructuous, because by
Till
Monday.
the next date, will you grant till the next date?
Your
In the
Lordship,
meantime, you get instructions, maybe in the next date itself, the writ petition can be disposed of.
Unless,
Isn't it?
Lordship,
The issue is very simple here, I think,
I have interim prayer, maybe allowed Lordship, unless I'm granted, the matter become infructuous, because by Monday they will evict me.
Okay, so get instructions and then after instructions, early disposal can be sought for.
Yes,
Okay,
Your
because the issues here are is quite simple, huh? Heard Mr. So and so. Mr.
D. Boye.
D. Boye, learned counsel for the petitioner along with Mr. So and so, learned government advocate, is it? For the
Yes.
state.
2, 3, and 4. Your Lordship.
Wait, we'll issue notice first. Okay, heard Mr. So and so, learned counsel for the petitioner. Okay, then this is an application. We will not mention government advocate yet. Okay? This is an application filed under Article 226 of the Constitution of India for issuance of the appropriate writ or order to the respondents with regards to the eviction order dated 19th No, we will not go through this thing. The main thing, the latest eviction order with regards to the
Latest interim order.
eviction order dated 23/07/2024,
Your Lordship.
passed by the learned Deputy Commissioner Changlang, AP, in case of C/JUD/Miss within brackets appeal number 03/2023. Full stop. The learned counsel for the petitioner submits that the said impugned notification / order dated 23/07/2024 was passed in violation of the principles of natural justice, since the deputy commissioner had not considered or heard the petitioner, nor the respondents in Miss Appeal number 03/2023. When the matter was taken up in the office of the Deputy Commissioner on 23/07/2024. It is submitted by the petitioner that the land in question where the eviction order against which the eviction order was passed has been in occupation of the petitioner for the last 14 years. And the impugned order was passed without due consideration to the submissions or the case of the petitioner. He further submits that the impugned order dated so and so, okay, may be stayed till the disposal of the instant writ petition. Issue notice to the respondents, Mr. So and so, learned additional, learned government advocate, is it accepts notice on behalf of the state respondents? Can you represent all the respondents?
No, Your Lordship, 2, 3, and 4 only.
Respondents number 2, 3, and 4.
Yes, Your Lordship.
No need to issue formal notice. Notice is to be issued to registered post with AD within 3 days to respondent number 1.
Your Lordship, 1, they had their own standing council, Your Lordship, land management.
Okay, so we'll issue notice to respondent number 1. Returnable by 3 weeks. Requisite extra copies of the instant writ petition to be duly furnished to learned government advocate. In the meantime, this court, on hearing the submissions made by the learned counsel for the petitioner, find it fit to stay in the proceedings / operation of the impugned order dated 23/07/2023 till the next returnable date. List on the date fixed by the registry. Yes. After 3 weeks.
Obligation.